Hello, morning everybody. What you have on the screen at the moment and in your packs is the only one of my charts that is as pretty as Helen's charts. And here it is. And if you look at it very closely, you will see that it has on it in tiny little writing, which is why you've got a bigger copy in your pack, so you can actually read it. It's at the back, by the way. And on there, the thinking was that in the look forward to 2018, I would sort of put in a sort of vaguely graphic format and vaguely chronological order key things that you might want to focus on for next year. And I'm going to talk about some of them in more detail in a minute. But in the small print, you will discover one or two things that I'm not really going to dwell on, but they're there. And one thing that I'm not an expert on, in fact, Helen is better on this than I am, but it's pensions. And I just thought that I'd just mention that the auto-enrolment minimum limits are going up in April, and also that there's a sort of tiny little amendment to allow employers to contractually enrol people into the government's pension scheme, National Employment Savings Trust Amendment Order, called NEST, and obviously someone's enormously proud of that acronym. And they've got to be, haven't they? It's just so good. And the reason I think that might be significant, even though I'm not a huge expert at pensions, is because there is obviously a gradual ratchet up of the compulsory obligation to put money aside for employees in defined contribution schemes. And obviously employers will be quite concerned about where they're putting their employees' nest eggs, because obviously the employer will want to see a good return on the investments. And I think Nest might be an idea to keep an eye on it, because it may become very big and substantial and could actually be quite a neat solution for employers if they want to be safe about where they're putting their employees' money. And I think all of this, my hunch, looking to the future with my crystal ball here, looking into my crystal ball, I have an instinct that the stuff around pensions could become gradually each year more and more and more significant in terms of what investment returns are you getting for your employees' money, what responsibilities do you have to look after their longer term financial well-being. Another thing not to forget about, not that I'm sure any of you who are from large employers have forgotten about it, is the full reveal in April 2018 around gender pay gap reporting. And that will be reporting by companies with more than 250 employees of the gap as defined by 11 particular matrices. I've got the wrong term, metrics, showing the difference between pay paid to men and pay paid to women. The good news is you've had the BBC go first, so there is absolutely no other organisation that can be so horrendously embarrassed as they were. So cheer up, it's not going to be as bad as that, but it could still be quite bad. And obviously one of the key things, once you've cut and diced your data in the way prescribed by the regulations, which is a fiddly, tricky little job, which I know organisations struggle with a little bit, but the real challenge is coming up, which is how to explain the data and what you do with the fallout later on. But we've talked about that quite a few times before, so I'm not going to dwell on that today. Small little bill that's going through Parliament at the moment is the Parental Bereavement Bill, which was talked about in the context of people losing babies. Actually, it applies to children up to 18 if parents are bereaved. 2 weeks per bereavement leave, and I think that's significant, with the crystal ball out again, because that's the first time we've, I think, unless someone's going to jump up and down and correct me, had any form of statutory bereavement leave. Yeah, nodding heads from colleagues, it's correct. That means that this could be the start of a trend, and one. So if you have statutory bereavement leave for children, which is obviously the most tragic case if you own children predecease you, but then what about other people, other bereavements, and is this coming down the line? So that's it. And there's a case that I haven't mentioned later on, but it links in with the gender pay gap reporting, which is ASDA are continuing to battle through the courts at great length. I think they're on to the third set of lawyers representing them, I hear, through the legal grapevine. Anyway, it's a massive fight going on. Tons and tons of barristers and lawyers are involved in the whole thing, and they've got as far as establishing that there is a comparison between retail workers and warehouse people on the shop floor, I mean, you know, the retail shop floor and people in the warehouse, and that they can be compared. But that decision is off to, it's going to be heard by the Court of Appeal in October 2018. So lots and lots and lots of work for the legal teams involved, and possibly new teams if they change again. Anyway, so that's something that we're all keeping a bit of an eye on in the legal world. I'm going to talk about the other things in the chart in relation to the now more boring slides that are coming up. And I hope they're boring but clear to follow. And one thing that I was not sure about when I prepared this talk was whether these next two slides, which, as you will see, are all about the European Union Withdrawal Bill, whether or not they were actually useful or not, because I wasn't entirely sure whether this audience would look at that and say, why have we come to a talk at Fox Williams to be told this stuff, we all know about it, or whether actually you think, oh, well, that really helps and it explains things a little bit. So what I have done is I've actually read a little bit of the Brexit Bill, which is going through Parliament at the moment, and as you know, it's massively controversial because Parliament has won the right to have some oversight over the Brexit process. And this is what it says. Now, it's subject to a hugely controversial debate, possible amendment, but the theory, as in this bill, is, as Sasha has said, that the exit date at the moment, 29th of March 2019, 2 years after Theresa May delivered the letter under Article 50. And on that date, in this bill as it is right now, the entire body of EU law is to be converted into domestic UK law on exit day. And that means that thousands and thousands of regulations and statutes and references to European Union law, and in this morning's talks you have heard constant references to European Union law and its impact on employment law. It runs all the way through employment law, probably 50–60% of it in this country. So it's a massive amount of law, plus a huge amount of case law. The entire body of all EU law that affects this country is to be incorporated into domestic law on that date. And I think the government have realised, or decided very early on, when they looked at the enormity of the task, that this was the only way to go. But what they have done is that they've put into the Brexit Bill powers conferred on government ministers to make regulations to rectify problems, and key point, to reflect any withdrawal agreement. I mean, I read that and I thought, aha, that is the tiniest little set of words, to reflect any withdrawal agreement. So giving to ministers the power under delegated legislation to effect a withdrawal agreement. What has happened when sharp-eyed MPs saw these weasel words is that they've gone bonkers and they have started talking about King Henry VIII and the Proclamations Act, and saying that this is just like King Henry VIII all over again. This means that ministers, without reference to proper parliamentary scrutiny, can implement all sorts of changes to primary legislation off the back of a need to just rectify problems and reflect the withdrawal agreement. So this has provoked a massive row. So that is one of the controversial bits. Now, is this helpful, going through all of this? Yeah. I'm just never sure whether, you know, the BBC talk about this stuff non-stop, and I wonder how much they actually explain it to people. Just like the referendum debate, how much got explained. Right, we explain things at Fox Williams. So after exit date, the UK Parliament and the devolved legislature, this is where Scotland starts jumping up and down, Northern Ireland starts jumping up and down, and they are very vocal, as you know, can amend or repeal any provision of this legacy EU law. So this is the bit of the bill which says that the UK Parliament resumes sovereignty and can now, so all of that body of law that is sort of frozen in time as of currently 29th of March 2019 can from that moment onwards be subject to amendment by the UK Parliament, which is sovereign again, Brexiteers whooping for joy at that point. And then over the page, and more whooping for joy from Brexiteers, no role for the European Court of Justice of the European Union, CJEU, in the interpretation of this law post-exit date. So at that point, you'll have a situation where Parliament can change the law, and the European Court of Justice, which has also been constantly referred to throughout this set of talks this morning, has no role in interpreting the body of law that we have now made our own, UK law. So from that moment onwards, the UK courts alone, this is what's in the bill. I'm not saying this is what's going to happen. This is the bill. UK courts will determine questions of interpretation of legacy EU law by reference to the case law as it exists on exit date, frozen in time, sort of frozen EU, CJ EU law. And one example of that might be the holiday pay, the case that Mark mentioned earlier, where if you are now a worker and your employer thought you were a self-employed person and you haven't had a holiday for 15 years, and on a worst case scenario, depending upon who is right amongst the commentators, you can claim your 15 years of back holiday pay under EU law. And in the past, we'd all gone, oh, God, it's terrible, you know, EU law, blah, blah, blah. Now we can go, oh, we can change that. We can change that if we want to. And there's two ways of changing that. Either Parliament finds time in the schedule, which is a big issue, you don't need me to tell you that, to change it, or it goes up to the Supreme Court and they change it. And one of the things that will be interesting is what the Supreme Court does. Now, obviously, you've got so much law that is subject to the EU legislature and to the court, then the UK courts will, in fact, be looking to Europe. And they can look at new decisions after exit date for guidance, and they can refer to them if they think it's appropriate for them to do so. And so they're allowed to do that, but it's at their option whether or not to have reference to that court, which will by then be a foreign court. And the CJEU decisions, like the holiday pay one that Mark referred to, will have the status in English law, in UK law, of Supreme Court decisions, and absent legislation. So if there's not parliamentary time to change all of these sort of detailed things about holiday pay or whatever else the government wants to change, and there will be a question mark over whether they want to change this stuff, but if they do, then it can, an alternative to Parliament changing it is the Supreme Court, because the Supreme Court will have the right to change that law, that case law, when it appears right to do so, if it's something that can be changed by case law. So they can override a European Court of Justice interpretation. And there is a debate, and it's in the Brexit Bill guidance again, as to whether the government will actually provide more guidance to the Supreme Court on where they can depart from legacy EU case law. And that's something that's going to be debated. So obviously, all of this assumes that we just leave cleanly and there is not an enormous set of agreements with Europe, which are very similar to the ones we have at the moment. And there's a massive debate going on, obviously, after the Brexit discussions fell apart yesterday over the DUP's blocking of the agreement that had apparently been reached relating to the border. There is a huge set of question marks over what type of agreements will the UK have with Europe. And if we do have very comprehensive agreements, as many people are arguing for, and in fact it may be very practical to have them, what role will the European Court of Justice have in overseeing those agreements? Or will there be some other form of dispute resolution mechanism? And this is obviously the issue that is absolutely getting everybody going in Parliament. Massive controversy over that. One thing that is a domestic political issue, again, you don't really need Fox Williams to tell you this, is that workers' rights, not only will workers' rights under the current EU law be preserved, but you already know, I think, that in some respects, UK law goes further than EU minimum standards already, and that for political reasons, the government has said, and this will almost certainly happen, that they will continue to protect and enhance employment rights, and they may deem it politically inexpedient to reverse certain bits of EU law, even if employers find them annoying, because, of course, there is a huge political dimension around the concepts of inequality, unfairness, and Theresa May and her government having gone out and said we want to address those inequality issues. And one of the main areas of inequality is around the balance of power between employers and employees and who gets paid what. And that is obviously, at the moment, and again, you don't need us to tell you, a massive political issue, but it will drive the domestic political agenda once we have left the EU. in whenever we do. So there it is. So against that political backdrop, and again, out comes the crystal ball here, I have chosen to talk quite a bit in this session about the Matthew Taylor Review of Modern Working Practices, which reported in July 2017, and the work of the Joint House of Commons Work and Pension Committee and the Business, Energy and Industrial Strategy Committee inquiry into the Taylor Review. They published their report on the 15th of November 2017, and they recommended implementing key aspects of the Taylor Review. And a key political point to note is that the cross-party committees that have come out with this recommendation are evenly balanced between Tory and Labour, with an SNP member in each one, and they all have agreed on this, and they say in their report that there is cross-party support for these measures. And so the issue is, will it get legislative time and government support to go through Parliament as primary legislation, even though Brexit is happening at the same time? And Brexit, as you all know, is having the effect of swamping just about everything else because it's so huge. So what is in this bill? Now, I've chosen to talk about the bill that the committees have produced, not the Matthew Taylor report, because the bill is the interesting thing, because it is based on the Matthew Taylor report. And the reason why I'm focusing on the bill is because this bill has come about through a highly unusual route, because the two committees, who are evenly balanced between Tory, Labour and with the SNP representation, have come together and jointly said, we think this is a very important change in the law. It also totally accords with Theresa May's social justice equality agenda, and in addition, the Treasury are very interested in this. So what this is all about is the gig economy, and I didn't stick gig economy across the top of my slide because I think it's slightly misleading to keep talking about the gig economy, particularly everyone thinks it's something to do with megabytes or gigabytes, and it's actually something to do with going for a gig. I think the whole thing is very misleading. So I'm focusing on the fact that this is about the pattern of work at the moment and how fragmented it has become, how many zero-hours contracts, how many contractors, how many people who call themselves as self-employed but probably aren't, people who work for lots of different people. And the end result of all of this is there's massive confusion about the law, there's massive confusion on the part of employees as to, or workers as to what rights they have, and key political point is the Treasury is suffering because they are not collecting the amount of tax and national insurance that they think they could collect if they tidied this lot up. So for lots and lots of different reasons, I think this could have legs. And getting the crystal ball out again, I think this could actually get parliamentary support and time to go through into legislation. And therefore, in looking at my crystal ball, I think you should all keep an eye on this. It's also stuff that goes to the heart of how business operates. So what exactly are we talking about? We are talking about the definition of employee, which is the status. If you see the bottom of my slide, employees have the full gamut of employment rights. Workers, who have some employment rights, not all of them, and there's the main list there. Note national minimum wage and national living wage, and a battery of other protections, holiday, and so on. And there is another category, which I've put up there, independent contractor, the genuinely self-employed and in business on their own account, who aren't covered by this because they run their own businesses. And the current situation is there's a lack of clarity around how all of these statuses are defined. And so you'll see that the committee have recommended that for employees there be a statutory test with a heavy emphasis over how the employer or the firm's exercise of control over how the work is carried out, and a difference between that and a worker who personally carries out work but is not under the same level of control. And there will be these sort of statutory definitions if this bill gets legs. And the key distinction will be between a worker who personally carries out work and an independent contractor genuinely in business on their own account. So that will be important for many employers. And another proposal is that both employees and workers receive a statement of employment terms and rights no later than 7 days after starting a new job, whether they're employees or workers. And these statements, if I've read the bill correctly, will actually tell the employee what their rights are in each status. And in a tribunal case, it will be presumed that an individual is a worker as opposed to a self-employed business person, unless the employer proves otherwise, which is reversing the burden of proof, which is another important change. Now, there's been a lot of debate about whether if you have the flexibility to work when you want through an Uber platform or a Deliveroo platform or so on, and you enjoy the flexibility, or whether you're an exploited worker. And if you are if you are working those sort of very flexible arrangements, you don't have guaranteed hours, then an issue as to whether the national minimum wage, the national living wage, should be increased by a premium to reflect the fact that you as an employee are taking, if you as a worker are taking the risk on your hours and you have no guaranteed hours. So therefore, when you do work, should you be paid more? And there's a recommendation, there's a proposal in the bill that there be a pilot scheme to allow for differential rates. So the people who have no guaranteed hours get paid more per hour, which is an interesting, that's been copied from other jurisdictions. I think New Zealand and places like that have that sort of arrangement. Something else that the committees looked at and the Taylor report looked at was continuous service, because you lose your employment rights if it's broken. People who work in the flexible economy do lose their rights, and the proposal is that instead of a 1 week gap resulting in the loss of continuous service, it be a 1 month gap. And also the Taylor report and also the bill and the committees, a heavy emphasis on enforcement and fines in relation to these sorts of compliance issues. And I think they're talking about the fines being used to fund a larger enforcement service, which is always a worrying sign, because obviously that's rather expensive, so that means big fines. Another thing, echoing Helen's point about data protection, is class actions, because she mentioned groups of people bringing class actions against data controllers. Here there is a proposal for class actions, genuine class actions, not just clumps of employees bringing cases together, but an actual class pursuing a claim through a tribunal to determine the status of a worker. So the Uber drivers, at the moment there's 11 of them who are deemed to be workers, not the whole, is it 40,000 of them, just 11 of them. If there was a class action procedure in this country, as they have in the United States, you could have a system whereby a representative of the class could bring proceedings in the employment tribunal, and people could either opt in or out of the class. And if there was a ruling in favour of the class, it would be binding on the entire class. That would be a very, very significant change to the way of enforcing employment rights. Regulation 30 of the working time regulations relates to the procedure for enforcing working time regulations, so that would get real teeth as well. And there's a provision that those claims could be combined with other claims. And that is definitely something to keep an eye on, but it's in the bill, so it could gain momentum. Also aligned to that bill, which has come up through a very unconventional route, is what the Treasury said, or rather Philip Hammond said in the budget speech, because they have said, and this is an indication, a very strong indication, that there is powerful government backing for change of the law in this area, that the government will consult on making tests for employment and worker status clearer for the purpose of both employment rights and tax and NI. And that is a massive clue, because that shows that the Treasury, most powerful government department, are interested in this. My hunch is there will be parliamentary time for this. And so that is coming along now. Now, some of you will know from our previous talks or just general reading that there are changes due in April around the payment of the taxation of termination payments. And we had thought that termination payments over £30,000 would be subject to national insurance as from April. That has been delayed by a year. The National Insurance Contributions Bill is delayed. And there's some little excuse in the announcement that it's delayed about, well, we've got to consult about some very small employers who pay whether or not they should pay national insurance contributions or something. Mark and I think this is a red herring and a smokescreen. We think that what is really going on, crystal ball out, we are speculating, right? This is not solid information. This is Fox Williams speculation time, right? We are dead suspicious that what's really going on is that the Treasury have kicked national insurance into the long grass into next year. You remember Philip Hammond came to grief on trying to change this in the last budget before the last election. And he got into trouble because it wasn't a manifesto commitment. So no longer got that problem. It wasn't in the last manifesto. So we don't have that problem. The problem is everyone in Parliament kicking up and objecting, particularly certain Tory MPs. And so what we think might be going on is that the government are going to try and work out the difference between employment status and define employment status and worker status, and then define the national insurance and tax attributes of those. And they will seek to recover more tax through introducing new collection mechanisms in relation to workers, that the Uber workers and so on. And we think there is probably going to be a combined approach to looking at employment rights for workers and also tax and NI. Smaller things happening this year, which are already in the pipeline. All payments in lieu of notice, whether contractual or not, are to be subject to tax and NIC. In the past, non-contractual payments in lieu of notice you could wriggle out sometimes. And then foreign service relief on redundancy payments. For those of you who are big international companies, that's going. Right, I'm now in trouble because I've overrun. So I'm now going to gavel and confuse the audience. We have one or two people are slipping away, so I have to speed up. Supreme Court hearings in 2018. The Pimlico Plumbers case, which is about worker status versus self-employed status under the current law, is going to the Supreme Court on the 21st of February. And that involved an ill Pimlico plumber, and it's all about his rights to disability and health benefits and so on and so forth. The Uber case, it just shows you how you can get caught out. I did all my slides at a very last minute moment and delivered them to marketing yesterday round about lunchtime to their total and utter despair. I was so late. And even though I was so late, overnight we have a new change. So my slide is already out of date. Uber is not actually going to the Supreme Court. They've refused leave to let it go to the Supreme Court direct from the Employment Appeal Tribunal. It's actually going to the Court of Appeal. So please amend that slide. And here we have a picture of the Supreme Court, and they will be sitting in judgment on all sorts of cases, but it includes the gay marriage cake case, which is where a bakery in Northern Ireland refused to bake a cake with the slogan "Support Gay Marriage," and the reason they refused to do that is because they had deeply held Christian beliefs, and this is an acute conflict between the right to practice a religion and to give effect to your deeply held, sincere religious beliefs, and the rights of the gay people to have goods and services delivered to them. While I was busy Googling away, trying to sort of do my research over the weekend, I came up with, guess what, another case on exactly the same facts going to the US Supreme Court this week. And they too have a gay wedding cake case, and this was where a refusal by a Christian baker to make a wedding cake for a gay couple's wedding, and that's actually in the Supreme Court this week, according to Google. So very interesting, and I just thought you'd be very interested to see a picture of the people who are actually going to be taking a decision on these issues shortly. And final point from me, corporate governance. The Financial Reporting Council is going to be asked by the government to review the Corporate Governance Code. This is a watered-down version of what Theresa May said on the steps of Downing Street, which we all love to refer to that speech because everybody remembers it. And she did talk about greater social justice, etc. But when you actually look rather hard at putting employees on boards and so on and so forth, all sorts of problems have presented themselves. So we've got a watered-down direction to the FRC to give remuneration committees broader responsibilities for pay and incentives across the company and for explaining how the pay for the populace at large compares with the people at the top and the ratios between the two. And of course, with gender pay gap reporting, we now have a mechanism for determining ratios. So there's a big temptation in government. Once you set the mechanism up, you can compare all sorts of populations within the companies and how their pay compares to one another. And there's a point about extending vesting and holding periods of 3 to 5 years and strengthening the employee vote at board level. So something else to keep an eye on. And another important point, possible voluntary set of corporate governance principles for large private companies and statutory requirements on private companies as well as public companies to report on all sorts of things. I can see people feel I've run out of time, so I will now shut up, and it's been a pleasure talking to you.